You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
Welcome to the Bloomberg Law Show. I'm Greg Stohr.
And I'm Kimberly Robinson. June Grasso is out this week.
Ahead in this hour, a challenge to JetBlue's Spirit Takeover could keep the merger from getting off the ground.
But first, a challenge to the SEC's long-standing in-house tribunal system came before the Supreme Court last week.
That seems problematic to say the government can deprive you of your property, your money, substantial sums, in a tribunal that is at least perceived as not being impartial.
That was Justice Brett Kavanaugh during arguments November 29th. He and his conservative colleagues cast doubt on the SEC's ability to extract civil penalties through in-house action, instead suggesting that those accused of securities fraud have a right to have their cases heard in a federal court with a jury.
To help us walk through this, we're joined by securities lawyer Susan Hurd of Alston and Hurd. Let's start where Justice Kavanaugh left off, with the notion that SEC administrative proceedings might not be impartial. So you're a defense lawyer. From your standpoint, what is the problem with the SEC's in-house judicial system?
Well, the problem is, I guess, first of all, they almost always win. When there was an active use of ALJs for disputed securities fraud claims, I can't remember what the statistic was because it's been several years ago, but they almost always won. And they had a much lower success rate bringing those same claims in federal court. You also lose if you're a defendant, defending yourself in front of the administrative law judge. You lose the jury trial. A lot of the rules of evidence don't apply or sort of apply at the whim of the ALJ. You don't have the same protections that you have to pursue discovery. Your ability to take discovery on what the SEC knows is truncated. So there are a lot of things where the deck feels like it's stacked against you when you're actively fighting against fraud allegations in front of the ALJ. And then, there's the problem that you don't see a federal court judge and you don't get the opportunity to have a Article III judge review the SEC's decision. This used to be the law, without exhausting all your remedies through the SEC. So you had the ALJ go through what was usually not a quick process of reaching a determination. Then the SEC looked at what the ALJ did, and you had to wait for them to decide whether they were going to approve what the ALJ, did. And only after you jumped through all of those hoops and there was an adverse finding against you, did you get access to a federal court, the Court of Appeals, to argue that the ALJ and the SEC got it wrong and you really didn't violate the securities laws. There are a lot of things about that people didn't like.
So can we talk about the particular case that was argued at the Supreme Court? The case started out as an investigation into hedge fund fraud. How did it morph into this major challenge to the SEC's enforcement power? Can you tell us how all this started?
Yeah, so basically classic securities fraud claims were brought against Mr. Jardicasi, and he tried to go to federal court. Well, the SEC chose to sue him in its administrative proceedings. He tried to go to federal court to stop the administrative proceedings because he felt like they were unconstitutional, the issues that were argued yesterday before the Supreme Court. And the federal court in that instance said, we can't hear you right now. You've got to go through the entire process with the SEC in order to get the right to come to us and complain later. So this case has been kicking around for an incredibly long time. Mr. Jardicasi had to fight against the claims that he had made misrepresentations to investors about the funds that he managed. and he had to lose both in front of the ALJ and in front of the commission before he got to raise his issues with the Court of Appeals, and the Court of Appeals agreed that the entire process that he had been subjected to for years was unconstitutional.
By the way, one thing that happened in the Supreme Court argument that I know I appreciated is that Mr. Jargos's lawyer told us all how to correctly pronounce his client's last name. So
Yes,
it is indeed
thankfully.
Yes, we're all on the same page there. Give us a sense, Susan, if you would, about what's at stake for the SEC. How many cases are we talking about at the SEC that go through this in-house process every year?
So when we're talking about classic securities fraud claims that are disputed, where the individual or the entity is fighting the SEC on the allegation that they violated the securities laws and in particular the fraud provisions of the securities laws, there are literally no cases like that right now in front of the administrative law judges. There used to be. There used to be when Mr. Jargos was originally pursued by the SEC. But because of all these constitutional challenges to the SEC's use of the ALJ that have been floating around for years, the SEC said, you know what, we're not going to fool with the ALJ process if we've got an active disputed fraud claim. So they already bring all those claims in federal court. So if the Supreme Court agrees with Mr. Jargos, that makes no difference whatsoever to those types of claims and the SEC's current processes associated with those claims.
Right. So before we get to what impact that could have, wondering if we can spend some time talking about what the justices spent most of their time talking about, which was this constitutional right to a jury. What's the argument that's being made here?
First of all, there's just kind of a fundamental fairness argument that's being made, that it doesn't make sense for the government to decide when somebody has a constitutional right or not. That was the point that Chief Justice Roberts made, where he said, and I'm not quoting him, but essentially what he said is, it just doesn't feel right to say that a defendant has a constitutional right up to the point when the government decides they don't want them to have that constitutional right. That feels wrong. That feels unfair. And so that seemed to be the tenor of a lot of the questions and a lot of the discussion that was happening. And that kind of rings true to me personally, because if you're looking at what constitutional rights a defendant has, particularly the jury trial right, it shouldn't matter whether they're being sued by the government or they're being sued by a private litigant. That constitutional right is as important, maybe even more important, when the government is coming after you than if a private litigant does.
There was Justice Barrett in particular was making a distinction between different types of claims that the SEC might press.
Yes.
Civil penalties versus disgorgement, which is basically trying to give money back to victims. Do you see coming out of this a world where in some types of SEC cases a defendant will have the right to go to federal court and in other types he or she won't?
I think that's where some of the members of the court are trying to steer things. I think it's possible, although no one can predict accurately what the Supreme Court is going to do, it's possible that the Supreme Court could pull together enough votes to say the particular type of fraud claim that Mr. Jargos faced has to be brought in federal court, and he has to have the option of a jury trial. And the reason for that is the type of claim and the remedies that the SEC sought against Mr. Jargos, they do have an analogous provision at common law. A lot of federal agencies pursue violations of the law that were unheard of and undreamed of at the time the Seventh Amendment was passed, but not the claim against Mr. Jargos. He was accused of fraud. And while there was some quibbling about how a fraud claim has been tweaked in the hands of the SEC, it has a common law brethren. And that's what could potentially be the hook that allows the Supreme Court to narrow its ruling to having an impact on the SEC in this particular context and leave untouched the other federal agencies that everybody seemed to agree shouldn't have major changes in how they operate.
Susan, let's hold there for a moment. Coming up on the program, we're going to talk more about the SEC's enforcement power and potentially the impact on other agencies with Susan Hurd. I'm Greg Stohr.
And I'm Kimberly Robinson. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Greg Stohr.
And I'm Kimberly Robinson, in for June Grasso.
We're talking about the Supreme Court's November 29th argument on the SEC's use of in-house judges. Justice Elena Kagan was incredulous when lawyer Michael McCulloch argued that Congress might not have the power to let a federal agency enforce a statute through its own administrative tribunals. She pointed to a 1977 precedent known as Atlas Roofing, which involved enforcement of the Occupational Safety and Health Act.
That's settled.
Well, it's settled only to the extent no one's brought it up and forced this issue since Atlas Roofing.
I agree.
In this context.
Nobody has had the, chutzpah, to quote my people, to bring it up since Atlas Roofing.
Kagan, in case it isn't clear, is Jewish.
We've been speaking with Susan Hurd about the Supreme Court case that could upset a key enforcement tool used by the Securities and Exchange Commission in enforcing the federal securities laws. Susan, will the court have to overturn that 1977 precedent if they're going to rule in favor of the challengers here?
I don't think they need to, and that was sort of Mr. Jargos's lawyer's point that prompted the comment you just played. If you read the Atlas Roof case, it turned on the fact that a federal statute created a new duty. And it was, OSHA rules and the fact that before anybody was injured on a job site, Congress had created a vehicle by which I think the term they used was you could prophylactically address dangerous situations before somebody was injured. So that was a new duty that had not existed at the common law. So I think you can distinguish between the particular type of securities fraud claim that Mr. Jargos faced, which isn't a new duty. Back in 1791, you had a duty not to defraud people, not to misrepresent. And so it isn't a new duty, given the particular nature of the claim that was being pursued against Mr. Jargos. I think Kagan's comment about, nobody's raised this with us, so it must be settled law, again, is kind of missing the point because the SEC hasn't pursued these claims administratively in quite a while because they didn't want to face these constitutional challenges. So the only way this gets to the Supreme Court is based on conduct from a while ago that takes that long period of time that we talked about to percolate through the commission and through the Court of Appeals before it's even ripe to come before the Supreme Court. So I think the delay between the Atlas Roofing case and the present appeal can be explained to a certain extent by the fact that, the SEC just isn't bringing these claims anymore. I don't think they have to overrule Atlas Roofing. In fact, that was Mr. Jargos's lawyer's point at the oral argument. I think there's a way to distinguish that case.
Susan, there were a couple other issues that the justices spent very little time on. I want to know whether you were surprised by that. Let's start with what was actually the third issue in this case, the notion that the SEC judges have an unconstitutional level of job protection.
Yes. I wasn't surprised that didn't get more attention because it's a very dry kind of academic constitutional challenge. And, the court has already kind of looked at appointment procedures for ALJs in Lucia. And it's kind of a technicality. I think the Seventh Amendment issue is sexier. It's more readily accessible. It's more compelling. And the court doesn't have to reach all three of the issues on which the Fifth Circuit based its ruling. All it needs to do is find one constitutional violation, and they can reserve ruling on the other issues. They don't have to take on all three. So I wasn't surprised at all by the focus on the one issue that, like I said, is just flat out sexier.
I'm not sure that I've ever heard the Seventh Amendment referred to as sexy, but,
It's first for me.
There was also this issue that the SEC has too much discretion to decide which cases go to court, which ones are going to be happening before the administration. Right. They didn't spend a lot of time on that one either. Is this sort of what you're talking about? They can sort of pick and choose, and this, any reason why this wasn't an interest for them?
They didn't spend time on that. The particular way it was briefed. The way it was briefed was this, again, an academic kind of doctrine called the non-delegation doctrine. This issue about whether it's appropriate for the SEC to control somebody's access to constitutional rights got discussed a lot, but just in a different way. So what had prompted, I think, Mr. Jargasi to say, this isn't right for the SEC to get to choose where they can sue me, that piece of it did get captured in yesterday's argument. They just put it under what they thought was the more compelling bucket, if you will, of a well-established constitutional right to a jury trial. So I think that flavor was still there yesterday. Mm-hmm. They just felt like that concept of fundamental unfairness, that the SEC calls all the shots, that just got packaged under a different constitutional doctrine.
Susan, what's your best guess as to how this case comes out? It certainly seemed like Mr. Jargasi was going to win. Did it seem to you like it was going to be that relatively narrow possibility that you discussed earlier, where it may affect the SEC but not necessarily other federal agencies?
That would be my guess. You'll recall there was some frustration from certain members of the court that what the broad potential impact could be of some of these arguments had not been fully briefed to their satisfaction. So I think the Supreme Court is always going to try to get away with the most narrow opinion they can, because that's how you build consensus amongst the justices. That's how you get the votes that you need. And also they don't want to be causing unintended potentially negative impacts to players who really weren't in front of the court, and they didn't get the benefit of their viewpoint. So I think they're always going to try to get the votes and build a consensus on a narrow version of a ruling. And I think the SEC, they have this unique situation that they brought a claim against Mr. Jargasi that had a companion version at common law. And that really sets the SEC's claim and the SEC's use of an ALJ in contrast to what happens every day with these other federal agencies. So I think it is possible to thread the needle, and they're really smart people. And if there's a will, there's a way. and I think they could write an opinion that is confined to the particular type of fraud claim that Mr. Jargisi was facing, and they don't have to worry that they're opening the floodgates to brand new securities federal court suits, because they already all happen in federal court anyway.
Susan, one thing I wanted to touch on before we wrap up is that there's really seemed to be a lot of skepticism, particularly among the more conservative justices, about the so-called administrative state. We saw Chief Justice John Roberts really noting that, the impact on Americans' daily lives from these agencies is quite different than it was 50 years ago. So I'm wondering, how does that factor into this case, and should it factor into this case?
Yes. So, Justice Thomas has written articles basically saying that, this whole thing jumped the shark many, many years ago, and we should completely start over when it comes to the administrative state. So there's definitely sentiment on the court that this whole administrative state has morphed into something that no one intended. And there was certainly, I think it was Justice Gorsuch who said it's not your father's SEC. So there is a perception that we have to take a look at how the system is functioning currently. We can't have blinders on, but they're going to want to stay away from the appearance that they're making policy. They're going to want to be deferential to Congress and the legislative branch. And I think the way to do that is to look at what was unique about the particular claims that the SEC brought. You can't, like I said, you can't have blinders on and create a rule of law that's going to be going to have negative consequences and potentially erode a constitutional value. But by the same token, they can't do what I think Justice Thomas wants to do, which is just throw out the baby with the bathwater and start over again. There won't be the votes to do that. So they're mindful of the current state of the administrative state, but they'll be careful in their opinion to try to stay within the role of what the judiciary is supposed to be doing, and leaving matters that have been traditionally a legislative function or an executive branch function to those other branches. They'll be thoughtful about how they attack the issue.
Well, our thanks to Alston and Byrd's Susan Hurd. Coming up on the Bloomberg Law Show, we'll talk about the government's effort to block JetBlue's $3.8 billion takeover of Spirit Airlines. I'm Kimberly Robinson.
And I'm Greg Stohr. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
I'm Greg Stohr.
And I'm Kimberly Robinson, in for June Grasso.
Trial is coming to a close in the Justice Department's effort to block JetBlue Airways from buying Spirit Airlines for $3.8 billion. It's part of a U.S. crackdown on airline consolidation. Here's JetBlue CEO Robin Hayes.
We agree with a lot of concerns the Department of Justice have expressed about airline competition. I've actually been making comments on this for years and years and years. We just believe the best thing that we can do to make a more competitive industry is to enable a bigger JetBlue. When JetBlue flies on the market, fares come down and service improves.
He made those comments back in February, just before the Justice Department filed suit. Joining us to discuss the trial is Bloomberg News antitrust reporter Leah Nylen. Can you just talk about how this deal came about? It's been quite the saga, hasn't it?
Yes. So Spirit Airways initially had a bid to be bought by Frontier. Those are both, you probably know them as very low-cost airlines. They're the ones who have unbundled pricing, meaning when you buy a ticket, you're actually just buying a seat on the plane, sort of like if you were buying a bus ticket. And if you want to buy anything else, like if you want to pick which seat you're sitting in, if you want to bring bags, even sometimes if you want water, you have to pay for it separately. So those two companies were considering a merger, and then JetBlue got a little bit jealous and made a counteroffer. Spirit Airways actually was not that thrilled with the counteroffer because they were worried about the antitrust concerns. And they had this big presentation that they gave to all of their investors about how it would be like a really big problem for antitrust. It was definitely going to get challenged by the regulators. But then JetBlue offered them a lot of money to go through with it anyway. So they ended up picking that deal over Frontier. The Justice Department then did end up suing, and we've been in trial since Halloween.
Sometimes you don't want to be right? So JetBlue and Spirit say the deal is necessary to compete with the big four airlines, American, Delta, United, and Southwest. So why is the government trying to stop the deal?
Yeah, so the government doesn't necessarily want you to fly Spirit Airlines. I mean, if you want to, they're cool with that. But the thing that they found is that when Spirit tends to start flying a route, it really ends up reducing prices on all of the airlines. They found that there's this thing called the Spirit effect. And so when Spirit starts flying a route, it tends to reduce the prices that are charged by the other airlines as much as 17%. And so it does have, a really big effect on everybody else. And the government is worried that if JetBlue ends up taking Spirit out of the market, that this price lowering effect is not going to happen for the other airlines. JetBlue, says that it really needs to bulk up to better compete with the big guys. But it freely admits that it's going to eliminate a lot of seats on Spirit's planes. It also says it's going to raise fares by as much as 30%. So it's not even walking back from that idea. It's just saying, bigger is better in a regulated industry like airlines.
So what kind of evidence did we see at this very long trial? What did the government present?
I mean, they called JetBlue's CEO, Robin Hayes, who, freely admitted some of these plans that they have to reduce the number of seats that they have on flights and raise prices. There was another thing that came out at the trial when Robin Hayes was there that was pretty interesting. JetBlue has had a lot of antitrust problems lately. This is actually the second antitrust trial they've had in the past year. Last year, the Justice Department sued them over an alliance they had with American Airlines, the largest airline, to partner up in the Northeast, so Boston, New York area. There was a trial over that. A federal judge in Boston found that it violated the antitrust laws and they had to unwind it. But JetBlue had this plan to sort of bulk itself up. First, it was going to pair up with American. Then it was going to buy Spirit. Then it was going to buy Alaska. Robin Hayes.
The state or the airline?
This is not Donald Trump buying Greenland. This was the airline. So they had these plans to really bulk up because they sort of decided that's the only way that they're going to be able to compete. So it was what we call a roll up in motion. So the Justice Department has focused a lot on that. One of the ways that Spirit and JetBlue have tried to sort of remedy what the Justice Department says is anti-competitive is by saying, okay, yeah, we do have a lot of flights that overlap, but we'll sell off some of the gates and such at some of the slot-constrained airports so that another airline can come in and fly some of these routes. So they've come up with a plan to sell some of those to Frontier and Allegiant, some of the other low-cost airlines. But the problem with that is Frontier and Allegiant don't have enough planes to actually fly all of these. And you may have heard that there's a little bit of a pilot shortage right now. Mm-hmm. There's also a little bit of a plane shortage because so many of the airlines sort of stopped buying new planes during the pandemic and now want to get them. And there's a little bit of a backlog, sort of a supply chain crunch on everything still. So it's not clear that Frontier or Allegiant would have the pilots or the planes to actually pick up some of these routes.
I wonder how the deal is being received by other airlines. Have we gotten any hint of how they view sort of combining forces of JetBlue and Spirit?
There's been a little bit. Spirit and JetBlue have called a number of the other airlines to come testify. There was someone from United in addition to someone from Frontier. A lot of the airlines have taken some cues from the way that Spirit flies. You may have noticed that a lot of the big airlines now have something called basic economy, in which, it's sort of the same idea. Here's a seat, you don't get anything else. That's sort of what they adopted from the Spirit. But unlike Spirit, where everything on the plane is this basic economy, on a United or an American flight, there's, maybe a handful of seats that are basic economy. So while they've taken the idea, they're not applying it to the whole plane because they still want those lucrative business travelers up front. The other thing that was really interesting is it came out that there's this sort of practice within the industry known as flashing. So all of the airlines have to put the amount of money that they're going to charge for a seat into this computer system called APCO. And it turns out that they sort of use this to signal each other a little bit about how much they're going to price.
That sounds problematic.
It is a little bit problematic. You're not really supposed to tell all of your competitors what you're charging. But they do this thing sometimes where if they notice that somebody is charging a lot more or a lot less, they'll send a sort of flash across the wire where they raise it really high for a minute and then drop it back down to sort of send a signal to everybody that someone is out of lockstep. And some of the people who acknowledge that this happens said, we know we're not really supposed to do that, but it didn't seem to hurt anything.
Were the Justice Department lawyers taking a lot of notes at that point,
They were.
preparing for the next case?
The point of highlighting this is that, the airline industry is already really consolidated. And if there are problems like this that already exist in the marketplace, if we allow it to get more consolidated, this sort of thing is only going to happen even more. That's sort of the purpose of them raising that at the trial.
Okay, so it's not sounding so good for the companies at the moment. What is their defense? What is their case that they are making in court for why, despite everything you've been saying, this merger is actually pro-competitive?
Yeah, well, they say, we do need to compete against the big four. Those are the biggest airlines in the country. They often charge a lot, and we'll charge less. We are still the lower cost carrier than somebody like American or Delta. So, they say it would be good for consumers because you will have this lower cost option. But really, a lot of people think the fact that this went to trial at all is because JetBlue offered Spirit a lot of money to let them go through with this. So if the Justice Department wins at trial, JetBlue has to pay Spirit $70 million and then Spirit's shareholders $400 million. And, that's a pretty good deal. All Spirit has to do is sit there and nod along while JetBlue makes this case, and then they might get $70 million at the end.
So the trial's been going on for a while now. Where does it stand?
Yeah, so the closing arguments are Tuesday. And then antitrust trials are heard by a judge, not a jury. So usually it takes somewhere between 30 and 90 days before we get a decision. So we'll probably have a decision out of the judge sometime early next year.
So, Leah, has the judge in this case given any indication of how long it will take for a ruling to come down?
He hasn't really. In general, these sorts of cases take a couple months afterwards. The government is seeking a permanent injunction, and in general, because mergers have timelines, they try and get these things done quickly. So usually it's 30 to 90 days after closings is when judges normally issue things. The judge hasn't yet indicated when he might rule. We're sort of expecting he might say something at closings. But he has asked a lot of questions about the proposed remedy. As I mentioned, both JetBlue and Spirit plan to divest some of their routes to Frontier and Allegiant. And he has been really interested in whether that's actually enough to resolve the competition. In a lot of the previous airline mergers that the Justice Department had allowed in previous years, they did on the condition that the airlines divest routes. So the most recent one that you might remember is American Airlines US Airways, which was the Obama administration, mid-2010s. The Justice Department originally sued over that one, and then they agreed to eventually allow it through after those airlines agreed to divest some gates at Reagan National Airport and up in New York at some of those airlines. But what the Justice Department found is when the airlines sold those gates off, the new airlines didn't always fly the same routes. So American might have been flying, say, DCA to Minneapolis, but the new company that took over, Frontier, might fly DC to Denver. And so even if you divest these gates, you don't necessarily replace the competition that's lost because there's no guarantee that the person who takes over is going to fly the same thing.
So stepping back a little bit, under Joe Biden, the government has really sought to crack down on airline consolidation after really decades of approving deals with little resistance. Tell me, what does that look like in the current administration?
That has been very interesting. The Biden administration is very focused on competition in a way that previous administrations were not. And so the interesting thing about this one is not only did the Justice Department challenge it, but the Department of Transportation very vocally also says that it's opposed. So on the same day that the Justice Department announced that they were filing this lawsuit, the DOT said that they are also concerned. And while they're waiting to see what the judge decides, even if he decides that it doesn't violate the antitrust laws, they still might take some action because in a case like this, the Department of Transportation has to approve the transfer of some of the licenses between the airlines. And so they have said that they may end up having a long proceeding about whether to actually transfer those licenses if the Justice Department doesn't block this merger outright.
And is this approach from the Biden administration just about airlines, or are we seeing this in other industries as well, concern about consolidation?
The concern about consolidation is economy-wide. I mean, one of the things that Biden has said is that he's very concerned about the number of industries that have become very concentrated, particularly regulated ones like airlines. And that's why he created an executive order in 2021 that ordered various federal government agencies to look into ways that they could try and improve competition across the board. And that has resulted in a lot of different initiatives. We've had this focus here on airlines, but there's been focus also on pharmaceuticals, on meat packing, because there are only a few meat packers left out there, actually, and all sorts of different industries that you might never have thought of. So, yeah, I would say this definitely isn't just airline specific, but even the Surface Transportation Board, where railroads have been involved, has been getting in on this competition side stuff.
That was Bloomberg News' Leah Nylen talking about the Justice Department challenge to JetBlue's attempted takeover of Spirit Airlines. That does it for this edition of the Bloomberg Law Show. I'm Greg Stohr.
And I'm Kimberly Robinson. This is Bloomberg.